Good evening, everyone. Thank you for joining us. Thank you to our usual attendees for being with us during our events. And I would like to welcome all our new attendees for today's or tonight's interview. Tonight, featuring a special guest and a special topic. Paul Sills is an international arbitrator and mediator with over 27 years of experience in resolving complex multi-party disputes. He works predominantly in construction dispute resolution and maritime disputes. He operates across different institutions such as the LCIA, Dubai International Arbitration Center, and many other institutions across the world. And it is a pleasure having Paul with us for this interview. And I'm looking forward to discussing many areas and issues about construction dispute resolution with him tonight, especially in the Middle East region. Welcome, Paul. It's a pleasure to have you with us tonight.
Look, thank you very much, and good evening, everybody, and thank you for taking the time to stop what you were doing and listen to our interview. So hopefully we can keep you contained about construction disputes.
So, Paul, construction disputes usually is something that many people try to stay away from, especially people who work in arbitration might take different areas of commercial arbitration and tend to stay away from construction due to the technicality it involves. And over here in the UK and different jurisdictions, we've always seen engineers take historically the role of resolving disputes or managing disputes which relate to construction. How do you see this landscape changing and the role of experts such as engineers in construction dispute resolution?
Good starting point. People do, I think, sort of stay away, as you say, from that perception that all construction disputes are technical. And of course, often there are significant technical aspects to them, whether it's design failures, the finer points of extensions of time, prolongation costs and their calculation, that sort of thing. So yes, they are heavily technical disputes, but I think if you have been working in them as a lawyer for a number of years, it's like all industries. You understand sort of the key areas where disputes are going to arise. You understand sufficient of the expert material to be able to be a part of that dispute resolution process, whether it's as a mediator, as a dispute board member, or as an arbitrator. And of course, increasingly, I guess there are significant issues also outside the technical. So contract interpretation is often a big one. And I've been dealing with that a lot in the Middle East this year. How to interpret even if you're using a fitted contract or an adaptation of that. The contract interpretation is very much in the bread and butter of looking at it from a legal perspective. But of course, you need good experts. And whether that's, an expert who's determining things like an engineer within the contract, or an expert that's been brought in by the parties to provide, a neutral overview, or increasingly whether it's an engineer sitting as part of the tribunal. So I've been doing some work recently in the Middle East where my two colleagues are both civil engineers. It can be a fantastic resource when you are dealing with the technical. And of course, they think I'm a fantastic resource when it comes to writing the awards.
I remember when you said that everything that's legal related and jurisdiction related, up to that point you'll be handling it, and then you need their assistance and their support when it comes to technical. But I started off with this question because when we were promoting for this interview, and even when I gave my webinar back in July, many people are not really interested in construction or find it a complex area. So if we want to remove the technicality and simplify it for our attendees over here or anyone who's going to watch this interview later, how would you simplify construction dispute resolution to be able to then dive deeper into the different mechanisms of dispute resolution?
Yeah, look, it's a good way of looking at it. And in its very simplest form, construction disputes are like any other commercial dispute. They are a dispute typically around the interpretation or the implementation of a contract. So a lot of the disputes are around the processes under the contract, whether they be technical processes, or whether they be things like variation. So it's at its simplest, a construction dispute is just another form of commercial dispute between the parties. So at its heart, if you are used to the environment of helping resolve commercial disputes and contract-based disputes, then construction is no different. And like any industry, it's got its peculiar or particular phraseology and shorthand code and processes, but they are really on top of that underlying point of it's a construction dispute. It's a dispute between commercial parties. And so in that respect, the hallmarks of why they are in dispute, the hallmarks of how the parties are going to react to the disputes, and often the processes that we can use to help resolve that dispute are the same, whether it's construction, energy, a joint venture, a commercial dispute, a family business dispute. They all have very similar hallmarks, and I don't think people should sort of look at the technical end of the dispute and say, oh, I don't have a role to play there because I don't understand nuclear power stations. Subject matter expertise and understanding, I think, has an important place, but increasingly your understanding of the components and the structure of a commercial dispute and how you might assist the parties, whether you be mediator, dispute board member, or arbitrator, is a really important part of the job. And that part stays consistent whether you're dealing with construction or a joint venture or just a breach of contract or a supply chain issue. The rest of it for me is the technical component is the added part of it. In theory, and I think justifiably at times, a good mediator or an experienced arbitrator can help resolve a very wide selection of disputes. We tend to stick in our areas of specialty because we think that's what the market wants, and sometimes it isn't what the market wants. But very often we're bringing a skill set to every dispute that we are assisting with, whether as mediator or arbitrator. And the other compelling reason for people who stay away from construction thinking about getting involved with it is just sheer volume. If I take construction, infrastructure, engineering, and energy, and they're all very closely related, and renewable energy, I would add to that, because that's really going to be about infrastructure projects. You're talking statistically something like 60+% of all international commercial arbitration sits within that space. And of course, within that, you get a variety of disputes like supply chain and things, particularly on renewable projects. So it's a very big area of practice to stay away from, because you either, sometimes people think the construction and going through endless pages of technical evidence and
lots of data
and lots of data is not for you or boring, but it's a huge part of the legal landscape everywhere around the world.
And speaking of what the market wants, and it's important to note that you see construction disputes in both their commercial and their investment or investor state aspect. In arbitration, it comes hand to hand, especially that, even more than that, there's this contractual chain of the multi-party involvement in construction disputes and projects, from the funders to employers, contractors, and everything. And you mentioned knowing what the market wants. And I'm tending to assume that many people, many practitioners, or even employers and contractors are seeing that the market wants the Middle East. And probably that's how we advertised for this interview. Also, given your experience in the region, whether in Dubai, Qatar, and elsewhere. how do you see construction dispute resolution over there, and the construction projects as a whole, the industry? How is it it's fast paced? How is it improving and developing with time?
Look, you're right. It is definitely fast paced, and it's an area, whether you look at the whole GCC or beyond, but the Middle East and extending down into Africa, and I think increasingly Africa in the years to come as well. A lot of it which will be financed and sort of run through the Middle East. I think, yeah, it's a massive growth area. Whether it's building new parts of Dubai, or the World Cup stadiums in Qatar, or nuclear plant development in Egypt, South Africa, and the apparently 16 or 18 other African countries that are looking at nuclear power as a renewable energy source. The volume of work in the region is going to be immense for a very long time to come, particularly around the development of renewable energy, the development of commercial interests outside of the traditional sort of oil and gas. And so whether that be financial centers, sport, the attraction of sports and business centers and that sort of thing. So there's going to be a lot of work. And of course, as soon as you add volume and pace to a market, you end up with more disputes. I think it's inevitable. And that's not a function just of the way business is done in the Middle East. It's a function of construction, and it's a function of doing things, as I said, at pace and at significant scale. And I think particularly when we add renewable energy projects, which will be massive infrastructure at scale, whether it's expanding existing grids or rail as a more carbon neutral source of transport, whether it's hydro or offshore wind or solar, and all the infrastructure and everything that goes with that, again, at pace. And often, we will increasingly see these projects introduce untested technology, leading edge technology, which again will add a component of conflict, whether it's commercial arbitration or whether it's investor state disputes because of foreign direct investment for a lot of these projects. So look, the region is going to be of great interest to the dispute resolution market for years to come, because it has really in the last few years in particular become a very dynamic place to do business and is seeing incredible growth.
And speaking of FDI, like it was seen a lot, especially in the United Arab Emirates, how much the rate of inward foreign direct investment increased over the years, especially in the infrastructure and construction industry. From your experience in the region, were there many of these projects in the form of public-private partnerships, or were the governments involved in the international, the cross-border mega construction projects, or was it just an employer-contractor, private employer-contractor relationship?
It's a strong mix of both, and it depends which country you talk about as to I think the degree of government involvement. But it is a function of the sort of leadership and royal family structure of a lot of the Middle East and the GCC countries, that the governments are heavily involved in business. And I always use sort of Singapore as a working model. I mean, in many respects, the Chinese model is the same, where the government has a very strong position to play in the growth of development, the projects, as you say, the public-private. So you often see, whether it's obvious or whether it's more in the background, a lot of government involvement. And of course, that's a hugely attractive thing in many respects when you are doing business in a region, particularly if you're doing it for the first time, or you are, foreign direct investment, is knowing that your business partner, so to speak, is there for the long term and is good for it. Particularly if you're the contractor coming in, you need to know that your employer is financially stable. Well, what better than the government to be that partner.
Depends which government. You need to make sure also that it's a strong government.
It depends which government, and it depends to a degree on where that government, where that country is in its development of it's the types of practices that attract and give comfort to foreign direct investment. So how well developed is the arbitration market in that country? Because of course arbitration being so readily enforceable and practiced around the globe, and reasonably harmonious in how we do it, even between civil law and common law. It's the favoured dispute resolution process of your foreign direct investor, because they understand it. There's a certain degree of comfort with it. There's there's significant enforcement advantages which are really important. So anybody coming into a region with foreign direct investment interests is going to look at the maturity of that market and look at how mature the arbitration laws are, the enforcements, how arbitration or mediation friendly are the local courts, what is the relationship between the arbitration community and the local court community, is there friction there, are the courts on track with supporting arbitration, because that's a fundamental role. So yeah, very sophisticated contractors, commercial parties, investors, are very quick to look at the strength of the supporting mechanisms for their investment or for their contract. Who the employer is the other leaders, is the royal family there, etc. That's a component. But if this gets into trouble, they will be saying to themselves, what are the mechanisms? Is it straight civil law? Is it sharer law? Is it a combination? These are important decisions for an investing party.
And you set the ground now to move forward with the discussion, and especially specifically look at the dispute resolution mechanisms over there. And we've seen also that the Middle East, different countries all around the GCC, they're becoming arbitration-friendly hubs, establishing their own institutions, having many cases referred to there. And the LCIA was also established in Dubai for a very long time before, like combining all arbitration institutions under the DIAC. And so even though you said that arbitration is still the preferred mechanism for dispute resolution for foreign investors, I think you and I both agree that it's also time for dispute facilitation and dispute management. And that's why we brought to the topic as well mediation and dispute boards. So
yeah, I think there's generally around the globe an increasing understanding of a few things. One is that not every arbitration isn't best practice for every dispute. Yes, at times having a third party determine matters for you is necessary. But I think we are starting to look at, and I think we are starting really globally on this journey of looking at better, faster ways to combine with arbitration to get these matters resolved faster, more cost effectively, and really reflecting, the need for parties to get on. We talk a lot about it, and it's a very important point, is that there aren't sort of many winners in a construction or an infrastructure project. Take a renewable energy project. If the project goes halfway through and it stalls because there's a dispute and it leads to a suspension by the employer or the contractor, and then an arbitration, or even if a project gets to the end but everything's been sort of pushed down the hill and there's this huge pile of matters to resolve at the end of the project. So the project might have lasted 3 years, but now we've got 2 years of arbitration to sort out the mess that's been left behind. A mess that's occasionally created because the parties, particularly contractors, have just tried to get on and get things completed. Perhaps they haven't followed the rigorous requirements of the contract in terms of variations and things. So arbitration is one of those, construction is one of those areas where we do historically tend to be left with this big lump at the end of the project. And so I think we're starting to look a lot more at, earlier intervention in these things, less contentious or less adversarial intervention and more facilitation. So, if we get on the front foot and we facilitate the relationships around a construction contract more proactively, with which is sort of the thinking now of dispute boards and the thinking of early intervention facilitation, can we assist the parties getting past those bottlenecks? Can we help them, resolve these matters in both a timely way and in a less contentious way, a less adversarial way, so that we are keeping the project flowing? Importantly, keeping the finances flowing, which is often becomes a real problem. So I think in its very early days in the Middle East, and every time I go there, people want to talk about mediation, but I think it'll be a year or two as we start to see it get more and more traction and be written into more and more contracts. Certainly the courts, the offshore courts, the DIFC, ADGM, very proactive in it. The onshore courts now in the UAE as well. So it's building momentum, and experience from other jurisdictions, New Zealand, the UK, US, who have been using mediation a lot for the last 30 years, would say that once we get past that initial understanding of it and the appreciation by parties and their lawyers of how to use it well, we'll see a significant pickup in that sort of facilitative processes. And we'll see them work, I think, a lot closer with arbitration. So we'll see arbitration and mediation processes working better together, all aimed at adding value to the party. So how to speed up the resolution of disputes, how to reach agreement on all the stuff that can be agreed, and really save the arbitration process, save that determinative process for a smaller volume, a more refined list of issues, the stuff that the parties really can't agree on or need some expert input on to resolve. So, and I think particularly as these projects get bigger and speed up, as I was saying earlier about, the infrastructure behind renewable energy projects and things, we're going to need to free up these disputes faster. These projects will collapse financially if we don't all get better, I think, at proactively dealing with the relationships, the disputes, the bottlenecks, the problems, because you can't have, you can in theory have a construction project without problems, but there's always issues, whether it's weather or supply chain or similar. So even with the best
sometimes unforeseen circumstances.
unforeseen, put a pandemic in the middle of it and look at it from a dispute resolution perspective. So I think the time is coming for these other, as I said, more facilitative processes to work closer in conjunction with. We can go to arbitration if we need to, but do we really need to on everything? Isn't there a large volume of disputes that we can get sorted by negotiation and just take the essential 2 or 3 issues to a much faster, much more confined, and therefore much more cost-effective arbitration process, for example?
Exactly. And to pick up on what you just said, I have a few remarks which I noted down. Like one of the key elements for a construction project, as you said, is always to ensure the continuity of the project and the completion of the project. And talking about, you said that every time you go now to the Middle East, whether for work or like professional events, you see more people talking about mediation. And I think for the last couple of years, this is because of the introduction of the Singapore Convention and trying to bring it in more as dispute resolution mechanism, not to remove arbitration, yet to go hand in hand with arbitration. And it's probably also like dispute boards will become an integral part of construction projects, not just to resolve disputes, but rather to avoid them from the first place. And I've heard many practitioners say that you need to bring in you need to make people more familiar with dispute boards. Some people are still unfamiliar with the concept of dispute boards, and for this reason, I think we should probably and let try and explain what dispute boards are, the different formats of dispute boards that are available in construction projects.
Yeah, look, a great place. So yes, dispute boards are a really interesting and potentially great part of that construction, engineering, infrastructure, renewable energy process. So they started in the 1970s in America on particularly tunneling projects. And it was decided that they needed a better process. Again, this whole problem with work stopping when there's a dispute, and whether it stops for short periods or long periods, it was just very unhealthy in the tunneling environment. So they devised a process called a dispute adjudication board, and so it was typically three people, and they would come from different backgrounds. You might have a lawyer, an engineer, and a QS, for example, and they would work with the parties from ideally the start of the project, a standing dispute board. And the parties, and they would meet regularly on site. They would be updated regularly by the parties in terms of progress and the like. And they would work with the parties on a real-time basis to help resolve disputes. It grew from there. It was used on big projects like the Hoover Dam. It was used in South America, used very successfully on the new airport in Hong Kong. So slowly it sort of moved out of North America, its home in the USA, and down into South America, and are now used regularly around the world. So popular are they in America that many of the funders will require a dispute board to be in place before they will fund. And I think that's a move we are seeing picked up by the regional and the World Bank and the regional development banks, that if they're going to fund, they want a dispute board. Why? Because statistically, even though the dispute board is an additional cost, you are paying these three people through the life of the project. Statistically, all the evidence shows that a good functioning dispute board does resolve most of the disputes, does aid a project being delivered closer to being on time and on budget, and leaves a lot less to be cleaned up afterwards, that big pile at the bottom of the hill I was talking about. So an example, the English Channel Tunnel, the famous tunnel between England and France, had all the hallmarks of being a problem child, massive project, a French English joint venture. So there's a sort of geopolitical rub and dynamic there. They had a dispute board on that project. I think there were 16 major disputes. 15 of them went to the dispute board and were resolved, and only one went to arbitration. So, from a time, cost, energy perspective, and incredible saving. These days, dispute boards are written into a lot of the construction or engineering contracts. So if you look at the FIDIC contracts, they are all embedded in there. Mm-hmm. Now, for many years, people in the Middle East have been putting lines through the DAB, or now the DAAB provisions. That's changing, and it's changing quite quickly, because again,
why do you think that? Like, why do you think, is it due to cultural obstacles or unfamiliarity about?
I think mainly it's a lack of understanding, and I would apply the same to ideas of what mediation is all about. Once people understand it, once people can see the benefits, and particularly once they can experience the benefits, there's quite a shift in people's thinking. So I think dispute boards, people on projects view it as just another cost of the project. And if you are running, dare I say it, an old-fashioned project where you are trying to allocate the risk to the other party in a potentially an unfair way, then you might say, well, a dispute board doesn't suit me, because they're going to force us to look at the middle ground and sensible resolutions, and I just want to push risk to the other party. But for example, on the FIDIC contracts, where their golden principles are very clear, that it's about, their contracts are all about the fair allocation of risk between the various colours. Dispute boards work really well. And so I think it's mainly education, because from a cost value perspective, they are very cost effective. And I think one of the big moves in the Middle East over the next few years will be the increasing use of dispute boards. Now, which I think is great, because I think they're a very valuable tool as long-term facilitation projects. The focus on dispute boards has changed since the sort of 1970s, when they were all about adjudicating the disputes and giving the parties either a recommendation or basically an outcome which the parties could then agree to be bound by or not. So a lot of the dispute boards now, the focus is on dispute avoidance. So the FIDIC, the 2017 contract, second edition, is now a DAAB, so a dispute avoidance and adjudication board. So the starting focus on that, if you look at the Chartered Institute of Arbitrators dispute board rules, same thing there, same thing with the ICC. The focus is on the resolution of the avoidance of dispute. So the dispute boards are becoming more and more proactive in working with the parties to see the disputes coming, to do basically horizon scanning for what problems are coming down the pipeline towards us. Are we going to get stuck on this variation? Are we going to get stuck on the supply chain issues? And working proactively with the parties to avoid the disputes, which I think is a fabulous change. And yes, we still have, they can still adjudicate, i.e. they can still give the parties a recommendation or an opinion if one is needed. So they can still act in that expert capacity. And yes, if the parties don't agree, they can still take that dispute to arbitration. So those layers of protection from a determinative process are still there. But I think for the majority of the disputes in these projects, they are proving very skilled and very useful at getting resolution far faster, far cheaper.
Paul, yesterday was the launch of the King's Worldwide Dispute Board report. It was all an empirical study, and they did statistics on more than 231 respondents from individuals, institutions, and even funders. And they asked many of the questions which were points you actually raised. And regarding the cost of the project, many funders and institutions says it does not exceed 10% of the entire construction project budget. And even if you do the cost benefit analysis, it's true that it might cost you some money, but on the longer run, it would save you because most of the decisions or recommendations that were issued by the dispute boards, even when they go to subsequent arbitration, most of the times the arbitrator's decision is almost the same as the dispute board. So
and something like 80 to 90% of the recommendations of the dispute board are adopted by the parties. And there's a lot of reasons for that, but of course a big part of it is relationship. One of the benefits of a dispute board, and a dispute board being there from the beginning of the project, is they have developed this degree of trust and relationship with the parties, so that when they do have to give an opinion, the parties are far more likely to sort of voluntarily go along with it, because they might not necessarily love the outcome, but these trusted advisors who might have been with them for 2 or 3 or 4 years, in some instances 10 years on some of these mega projects, that counts for something. And it counts for something when you are helping the parties on a dispute board resolve a dispute without arbitration. And it accounts for something when you are providing your recommendation. So there's a lot of power in that process. And again, it's not to eliminate the need for arbitration. All too often, I think practitioners who are either arbitrators or mediators think that their process is the answer to everything. Mediators are often guilty of thinking we can mediate everything, and that's just simply not true. I'm a big advocate for hybrid solutions, working out what is in the best interests of the project and applying that, whether it's a mix of arbitration and mediation, whether it's an early neutral evaluation followed by a mediation, or a non-binding expert determination followed by something else. That's what I think we should be doing, and that's where I think we should be going, is using these processes more as a toolkit.
And you've done both, like you've mediated disputes and you've arbitrated. You've acted as an arbitrator and you've acted as a mediator several times in the region in the Middle East, correct?
Yes, correct. And I'm a dispute board member as well, so I get the benefit of seeing all of the processes at work. And people often say to me, well, which do you prefer? And I say, well, you might not believe me, but I don't have a preference. What I have a preference for is using the right process at the right time.
So you eliminated one of the questions I had in mind for you. I won't ask you which one you prefer. Okay, so I'd ask you which one did you find parties in the region more cooperative with? Was it the boards, the mediation, or the arbitration? Now, definitely the arbitration is more, let's say, there's this binding effect and the finality effect of the arbitration, so it's treated more heavily. However, if we look at the boards or the mediation, which one were parties more?
Yeah, look, it's interesting, and I think part of that comes back to the education point. It's parties' understanding of the process, and the fact that they're not determinative. That as a mediator, I'm not there to make a decision. I'm there to assist with the conversation, the flow of information, the negotiation between the parties. So some parties who haven't been through that process before turn up thinking it is adversarial, or parties turn up thinking, oh, well, this person at the end of the table, we have to somehow convince them of something. So you get these very sometimes formal addresses. But once people get used to the process, and you start building up some trust and a relationship with them, I find them all generally really well received. Of course, as you say, you get a more formal position as an arbitrator, and that's understandable. And we have to be a bit more standoffish as an arbitrator because of natural justice requirements and things. So you have sort of less of that relationship opportunity when arbitrating, and so it's always a bit more formal. But I mean, it's still a very polite, very engaged, often collaborative process when it's run well. So I mean, all of them are great but particularly once the parties and their advisors understand, so that's what it means to be in mediation. So I don't have to be an advocate. I can be I can bring a different
Okay.
style of negotiation to this process.
Now, I want to go back again to your role in the region and your active participation in different institutions, different disputes. Um, what law did you see governing most of the contract, the merits? Was it like English law? Was it the law of the United Arab Emirates or Qatar, depending on every country, or was it mostly English law?
Very much depends. And even in the UAE, I have done both civil law, so it's been based upon UAE civil law, or I've been working on, in the offshore courts, and it's common law. And I teach, master's program here in London, so I'm used to teaching international students from both schools of thought. So for me, I'm lucky, I guess. It's quite a fluid process for me to think whether I'm in a civil law jurisdiction or a common law jurisdiction. I'm very happy with both, and I see a lot of the practices being very similar. I think that's one of the benefits of the work done in the last, particularly 2 decades, in harmonizing arbitration law around the globe. And I see less of a distinction now than there might have been, say, 20 years ago between how civil law practitioner or a common law practitioner would approach that, particularly in the international space. So that's I think a fantastic thing, and I think institutions, whether they be sitting within a common law jurisdiction or a civil law jurisdiction, have had a big role to play in helping harmonize it and helping sort of bring a degree of familiarity to the rules. So I think that's a huge. I keep saying to my students, it's an incredible benefit of arbitration is to have this harmonized, enforceable process. Whoever wrote the New York Convention in 1958, leading up to it, it's an incredibly clever piece of writing. But
And
it gave us a very defined starting point in terms of the recognition of arbitration agreements, and it gave us a very defined, incredible end point in terms of enforcement. But we've had to fill in all the gaps, and I think globally, and the Middle East is certainly a part of this, we've filled in those gaps pretty well these days.
yeah, exactly. And especially now, like as you said, the courts are more collaborative, more cooperative with the arbitration institutions, the awards, and it's a friendly hub for this dispute resolution mechanism. Now we have lots of questions coming in the Q&A, and
Great.
I believe this topic is getting lots of interest. Now I will start asking the questions. If any of the attendees do have questions, feel free to drop them in the Q&A or raise your hands if you'd like to ask them yourselves. First of all, how does Islamic law influence the adjudication of construction disputes in the Middle East countries? Do you think it influences or not?
I think the answer is yes. If you are doing a matter which is governed by, let's take an example, UAE civil code, then Islamic law has influenced the structure and the shape of that. When Napoleonic civil code was introduced to Egypt has developed 200 years of sort of rich history around it, and it's filtered its way through the region. It's inevitable that each country brings its cultural influences onto that civil code. I think the influence is less than it used to be. So, we used to see some quite strict requirements in some of the jurisdictions for the chairperson to be, a student or a professor of Sharia law. And so I think some of those stricter requirements are going, but, an important part of dispute resolution is the cultural influence. And I think that's important for arbitration as much as it is for mediation or dispute boards. And so, I think it should influence. And I think that's one of the important sort of, abilities of the framework of arbitration globally, that it can accommodate some of that within the sort of the richness of its process and things, and there's particular obligations that apply to contracts like construction contracts, in the UAE, for example. So yeah, it's certainly there, but it's certainly possible, I think, to come in and sort of be respectful and gain an understanding of it and work within that structure.
And Paul, having said that, you worked with both the civil law system and the common law, and you saw the different legislations and related probably. And since construction dispute resolution is not just one specific law, it's a framework of different laws involved. What legal reforms could you improve in the resolution of construction disputes in the Middle East? What are we still lacking in the region or in specific countries, if you'd like to specify?
Great question. I think these days, and this would be a different answer 20 years ago. I think these days a lot of the laws are in the right place for the dispute. I think it's more about how people approach the disputes and some of the perhaps contractual particular aspects. And one, for example, that always comes to mind, and it's certainly the case in the UAE, is this still using the concept of pay when paid. So these back-to-back provisions that say when the contractor is paid, the subcontractors can be paid. And that's one of the differences, because a lot of jurisdictions around the world have legislated against that, because it's this fundamental roadblock to the flow of finances, and it's this idea of a fairer allocation of risk. So for example, so that I think is a contractual point that can cause some issues, and does cause some issues, as it does, as construction has for 100 years around the globe pushed a lot of the risk or the burden onto the parties like subcontractors, who are least able to do anything about it. And so that knock-on effect of the payment regimes, I think, is really important, because it's dare I say it, it's an older style of looking at a construction contract, is to over allocate or unfairly allocate the allocation of risk. And that's why it's a part of the golden principles of FITIC, because we know from years of statistics that a fairer allocation of risk will result in a better project.
Risk allocation plays an important role, like in managing construction projects overall. It's also helpful for the insurability of the project and different areas of risk mitigation and risk avoidance.
It's incredibly important for a healthy project.
Mhm.
It's incredibly important for the financiers, I think, to see those risk mitigation, those almost, as you say it, insurance aspects of the contractual relationship. So a dispute board is one. I would go to any underwriter on the planet and happily argue that if they're about to underwrite a project that has a dispute board, their risk is reduced.
Exactly. And I think, like many projects which involve the government or are in the form of public-private partnerships, even though the government does not want to bear the cost of a dispute boards, it tries to mitigate the cost to the contractor, but yet make sure the dispute board is
Well,
present.
I think yes, but I think that is changing. And I think, and I put governments in this role as well. The financiers are having the biggest influence on the introduction of dispute boards, because they see the benefits from their perspective. It better ensures their risk of the finance of the project going wrong, and therefore their finance being at risk. And certainly some of the governments, and I'm thinking in particular of my recent discussion I was having about some of the commercial investment in Abu Dhabi that is government backed, they are requiring dispute boards on their new projects. So there's been quite a movement towards understanding the benefits of these. So I think we'll see quite a significant lift in the region on things like dispute boards and mediation, because in part the financiers are going to request it. And so that will bring a degree of maturity, I think, to this understanding of the benefits of a fairer allocation of risk on a project. You're always going to have problems where, you might be incredibly tight on finance, for example, or the finance might be private. And so an employer will think, well, I've got the negotiating power to push the risk elsewhere. And that might be fine. And it's, ultimately it's a contractual negotiating point. But, on these big projects, a fairer allocation and the parties understanding the allocation of risk and how it works and what their responsibilities are goes a long way to helping ease them through, the bottlenecks and the problems.
And like I could use this to build on for the next question. I think when governments are studying risk allocation, it's one of the factors that they take into consideration to choose whether their next infrastructure or construction project is going to be and one of the different forms of public-private partnerships. So do you see them increasing in the region, public-private partnerships in construction and infrastructure projects?
Look, yes, I do. I think that mixed model of financing is going to pick up. And again, if we look, at renewable energy, renewable energy is one of these interesting sort of areas which doesn't sit purely in the private sector, doesn't sit purely in government, even though governments have significant responsibility around, the climate change aspects and stuff. But all importantly, the financing of these things is incredibly important, and we're seeing huge movements globally in hedge funds and private equity and others in investing in infrastructure. So we know it's of interest to them. Infrastructure, building bridges, tunnels, etc., can show really good returns for these investments. So, and governments, of course, need to be seen to be doing stuff, and they're going to be under increasing pressure to introduce these projects and introduce the sort of scale that we're talking about, just increased electricity usage between now and 2030. So I think the joint venture model, whether it's in its current form or other, is just simply going to increase. So and the role of the development bank in green investment has and will continue to increase, and they should all be using their influence as funders to encourage, I'd love to say pressure or demand, encourage the parties to be looking at dispute boards, early facilitation of disputes and these things, because quite frankly, everybody wins.
And and we have one more question from the same attendee. What or can sociopolitical conflicts influence construction disputes? To what extent do they undermine the effectiveness of mediation?
Fantastic question. Thank you. And if we've got 10 hours, we'll talk about it all. One of the biggest issues we are facing is something that certainly the West had convinced itself it didn't need to face anymore, which was geopolitical risk.
This we talk about a lot.
Yeah, and of course, as people living and familiar with the Middle East, you would quite rightly say, well, we're kind of used to that now. We've had that for quite a while. And the answer to that is, of course, that is true. But the globalization of that risk, I think, has a really is one of the critical aspects, I think, of this time on the planet, and where it goes, how it develops, is going to have a huge impact on all aspects of what we've been talking about in construction, etc. Whether it's the financing, whether it's the willingness of parties to do business together, whether it's the willingness to collaborate or reconcile disputes or to facilitate disputes. So, yeah, we're moving very quickly into a very complex environment, one that we thought we had got rid of post the Cold War really earlier. And so I think it will have a big impact on things. For starters, it's going to
Especially
create.
on enforceability, like we always discussed how this will affect the enforceability of awards, the idea of sanctions as well. It plays a huge role in
Well, it plays a huge role right through, I think, the life of a project. It makes financing more difficult because suddenly financing becomes more geographically confined potentially, because for certain financiers, because of sanctions or just risk assessment, won't finance perhaps where they would have previously. Enforcement, we will see far more potentially political influence in enforcement, or political influence on the public policy aspects of enforceability or arbitrability of disputes,
Russia is
because
doing that, you know.
well, correct. So you can't arbitrate a tortious claim at the moment in Russia. So that's a huge, shift away from the mainstream thinking around the globe of arbitrability, which has been getting broader and broader, not narrower. So that's it's a very good question, because I put that to my students here in London about, where will enforceability interests go with geopolitical interests. So yeah, we are moving into, and it's very cliched to say, but we're moving into a far more conflict driven landscape. I think the volume of conflict, unfortunately, is going to increase significantly. Some of it because of things like the size and scale of projects and financial pressures, but geopolitics will have a huge role to play in the complexities of dispute resolution, as will climate mitigation patterns, migration patterns, sorry. So yeah, I mean, most of the textbooks we've grown up with, or I've grown up with, will be thrown out shortly because it's a very new landscape.
Okay, thank you so much, Paul. And following up, one more remark to, to the attendee who asked the question, and to everyone. Geopolitics or geopolitical instability is also like one of the key drivers that states use through sanctions to sometimes stop a certain project or drive for a certain project forward. So this is also something to be looked at. Last question, Paul, is actually from myself, and it's a bit away from construction dispute resolution, because I already asked you a lot about that. Is it true that you cycled from London to Paris Arbitration Week earlier this year?
It is true, and what's also true is that we're doing it again in 2025. So yeah, I think there was 14 of us rode from London to Paris for the
You,
start.
alongside Catherine, the CEO of the Chartered Institute of Arbitrators, you cycled to Paris, correct?
Correct, and
How was,
Catherine is a fantastic endurance cyclist.
how was your experience cycling in April, I believe, to
It was late March, and let's just say the weather is a challenge. So I've done worse. I've cycled also from London to Caen in the south of France over 7 days at the same in early March, and the weather is generally, let's just say, unfavourable for cycling. But the Paris Arbitration Week cycle, we're hoping to get people from all over the world. We know that we will. We're hoping to have about 50 people this year, because it's all run for a charity here in the UK. So it's a cycling charity. They organise cycle rides like this, and they're fantastic, Club Peloton. And in exchange, we raise money for the 4 or 5 charities that they have, which is working with lots of homeless kids and stuff. So it's a great experience. It's a great way to meet arbitrators and lawyers from all over the world. And you end up on a Sunday afternoon in Paris, tired and cold, and ready for a glass of champagne, and then Paris Arbitration Week. So it's pretty good.
That's amazing. Thank you for all the charity work you do, and good luck with that. Good luck with all your arbitration, mediation, and teaching. And you also take a huge part in the events that CR conduct in London and elsewhere. So thank you so much for taking the time and being our guest for tonight. I hope all the attendees benefited from tonight's interview, and so will everyone else watching it later on. Thank you so much, Paul, and I hope you had a good time.
I loved it. Thank you. I love talking about this stuff. So, yeah, as you can probably all gather, I could do it for hours. I generally do. So thank you for the invitation.
My pleasure, and thank you, everyone. Have a great rest of your night.
Thank you.